I'm curious about your opinion. So, as you pointed out, originally passed 50 years ago. It's been a very long time, obviously, and the amendment seems like such obvious common sense that it's sort of fundamentally offensive that it's taken this long to even get close to it potentially being passed. But I'm curious, like I watched Miss America when it came out in the last year, and you saw the radicalization of people against the ERA and how that played out with the right wing and all of that. Were it to be reintroduced fresh in 2021, do you think enough Republican senators would actually support it? Do you think that, like, if it was to be redone, that enough states would potentially ratify it? What is your opinion about that?
The concern with starting again, this is.
Well, I'm not advocating for that, by the way. I'm just curious as a thought experiment.
I think it's still going to be a battle. And unfortunately, as we know, discrimination on the basis of sex is, and the reason we need this is the reason why it might be a battle. Unfortunately, there are people out there who want to continue to discriminate against people on the basis of sex. And that's why we need the amendment. So I think there would be a fight. I think the good thing is it is a bipartisan issue. There have been a number of people and a number of representatives, a number of, if you look at general, they've asked questions of the general population, and something like 93% of people support this amendment. So it really is a bipartisan issue. It's something that many people hold near and dear to their hearts and have been fighting for across these party lines for decades at this point. So I don't think it would be in a quick and easy process. But I would like to have faith that there are enough people who would be able to recognize the need for it and move to make it happen. The problem is really why should we do that when we have a ratified amendment, right? We've done it, it's happened. And as a maybe point of interest, it wouldn't be the oldest amendment to be ratified. Not even by close. The previous amendment to get ratified, the 27th, was 202 years in the making. Wow. And yeah, it's a really interesting one. It's the basic idea is if Congress votes to give themselves a raise, it shouldn't kick in until after they've gone through an election period, basically until you might be out of office again. The idea is, no corruption, don't try to immediately benefit yourself. Took 200 years, but in 1992, the final state recognized, yeah, we really need this. And so sometimes we really see that issues that were present even 200 years ago don't just resolve because of other means. And we're seeing that with the ERA. It was necessary in Alice Paul's time. It was necessary in 1972. It's necessary now.
One final question, sort of just looking ahead. In theory, let's say that you're successful. The DOJ rescinds its opinion. The Archivist says this is part of the Constitution. Thanks to the change of the Supreme Court over the last 4 years, my assumption with any positive change to American society or legislation is that the Supreme Court will attempt to overturn it. In this case, though, once it's declared to be part of the Constitution, there's no route for the Supreme Court to challenge that. I mean, they interpret the Constitution, they don't determine that something can't be a part of it. Is that a fear, or is that outside of the bounds of a concern for ERA advocates?
It's certainly something that advocates are prepared for, and it is actually a question that has come up before the Supreme Court before. And I mentioned this case really briefly. About a century ago, there was a challenge to the Prohibition Amendment, actually. And it was essentially that question. There was a time, and it was on the same question of a time limit, right? But the time limit, as we discussed, was in the amendment itself. And that's when the Supreme Court said, well, it's in the amendment, it's part of the amendment, that's acceptable. It was a little bit of a different question because what the defendant accused bootlegger in that case was saying is, well, maybe it wouldn't have passed so fast if the time limit wasn't in it. So, does that make everything unconstitutional? And the Supreme Court said no. But so the Supreme Court may well weigh in on it, but I think the initial step is let's confirm that the steps have been met. Congress passed. So of 33 quarters of the states.
Awesome. Well, as we alluded to earlier, this is a fight that if you're passionate about this, you can get involved in, and I hope that you do. Courtney, really appreciate you both engaging in this fight and also joining us to break it down here on the Damage Report.
And thank you so much for covering this, and thank you for having me.
Check out the Damage Report podcast each day, wherever you get your podcasts, whether Pocket Casts or Stitcher or iTunes. You can join me as I give you the news and stories you want, with a range of co-hosts and interview guests jumping in on the fun each day. Again, that's the Damage Report, wherever you get your podcasts. And if you get them at iTunes, don't forget to rate and review. Sometimes I'll read them live on the show.